New Mexico police officers got a brand new case from the New Mexico Supreme Court. It's a mammoth, 35 pages, but it deals with two important search and seizure topics, very unique to New Mexico law. I'm going to tell you what you need to know about this new case in this episode of the podcast coming up. What's up, everybody? Welcome back to the Tactical In-Service Podcast. I'm attorney Eric Scramlin. Of course, this is a podcast for law enforcement where I break down training topics in case law to help you, the law enforcement community, stay up on the law. Today, I'm doing an episode on a brand new case. The case is State of New Mexico versus Francisco Javier Granados. This is a recent case just released about a week or two ago from the New Mexico Supreme Court. It's not new case law, but it is a reminder of some subtle differences and one not so subtle difference under New Mexico law. If you're an officer from another state or jurisdiction, you're probably not going to take much value from this episode. This is a case that's going to be very unique to New Mexico. Most states don't follow this. Under a Fourth Amendment analysis, everything would be lawful in this case, and the evidence would not have been suppressed. This case is one of those cases that I tell my New Mexico officers, it's applying New Mexico's interstitial approach, and it's giving greater rights under the New Mexico Constitution than the Fourth Amendment. So we have an example here where probably lawful under the Fourth Amendment doesn't pass constitutional muster when it comes to New Mexico's version of the Fourth Amendment, which you should all know, Article 2, Section 10. So I'm gonna jump in here and do a real quick breakdown. The case is 35 pages long. I'm not going to go through all of the facts and all the stuff. There's two important topics that you as a New Mexico officer need to know about this case. What are they? All right, first of all, quick version of the facts. This case dealt with a drug task force relying on a reliable, confidential informant. Apparently, this was an informant that had been used many times in the past and produced reliable information. But this is a rut we can get stuck in sometimes. I teach this in advanced search and seizure, which, by the way, is coming up. New Mexico officers, at the end of March here, I have my advanced search and seizure for task force agents in Lovington, where I'm going to teach you how to avoid this situation when it comes to drafting search warrants or how you rely on confidential informants, what the test is in New Mexico. But anyway, this case dealt with a drug task force relying on a confidential informant who told one of the task force agents that defendant was in possession of a large quantity of drugs. So they start surveilling the guy. And to make a long story short, they follow this guy to a gas station. At the gas station, another person gets involved, and they decide they're going to make contact with him. So the task force agents come up, identify themselves as police or Otero County Sheriff, and attempt to seize this person. Well, he takes off and flees. As he's fleeing, they chase him. He's throwing stuff out the car. One thing is a bundle of something that they would later determine to be drugs, and then they catch him later down the road. So they file a motion to suppress in this case. Here's the two big issues that the Supreme Court dealt with that you need to know. Issue number one, was the defendant seized? Now, if you take one of my classes before, I spend a lot of time going through to make sure you understand the definition of a seizure. If the defendant's seized for Fourth Amendment purposes, for New Mexico constitutional purposes, then at a minimum, what do you got to have? You got to have reasonable suspicion if you're going to seize someone. All right. In this case, the agents identified themselves, gave him some commands, and the guy took off. And then he abandoned property before they caught him. So question number one, was the defendant even seized? If he's not seized, there's no Fourth Amendment issue. The drugs are abandoned property. It's admissible. If we apply a Fourth Amendment analysis to that under the Supreme Court case Hodari D, it's admissible because Hodari D under the Fourth Amendment, the United States Supreme Court says that a person is seized when an officer gives a show of authority and then that person submits to it. If there's a show of authority and the person takes off and abandons property, they're not seized. So that abandoned property is fair game. New Mexico, of course, does not follow Fourth Amendment case law. So this is not new case law, but it's a reminder. The court saying, hey, we don't follow Hodari D. So the court determined that the defendant in this case was seized for Fourth Amendment purposes at the moment a reasonable person wouldn't feel free to leave. When is that in this case? When the officers pulled up, jumped out, had badges and guns, and yelled police. That's the moment the defendant was seized. In that moment, at that split second, the task force needed to have reasonable suspicion to support that seizure. We can't rely on Fourth Amendment case law saying, well, they didn't submit to it, so no seizure. Our courts determined that to be a seizure. So that's point number one. If you're a New Mexico officer, if you give a show of authority, pretty much any show of authority, and a reasonable person would interpret that as their freedom to leave has been terminated. So if you show up and say, police officer, come here, don't move, whatever, that's going to be a seizure. In that moment, you must have reasonable suspicion to support it. So in this case, the state argued, well, the task force did have reasonable suspicion to support it because it was based on a confidential informant, and in the totality of circumstances of everything they saw, there was reasonable suspicion to detain the defendant at the moment that they did. So to address that, we go on to the second point of this. Point number two, if you're a drug task force agent, or even if you are a regular field officer, how can we use a confidential informant under New Mexico law to establish reasonable suspicion to detain someone? Usually, we're using a confidential informant for probable cause to draft a search warrant. The same test applies. New Mexico follows the Fourth Amendment United States Supreme Court case, Aguilar-Spinelli, what we called in law school the Texas two-step, because it's a two-prong test. In Aguilar-Spinelli, there's two prongs that the court will look at to determine if you have reasonable suspicion to detain someone, or usually the case is probable cause to get a search warrant. Prong number one is what we call the reliability or basis of knowledge prong. So what that means is you have to be able to articulate in your affidavit for your search warrant or in your criminal complaint or your report, you have to be able to articulate reliability of the informant. In particular, what is the informant's basis of knowledge? Usually, what's been tried and true is a controlled buy because you're observing it. It's under your control. That usually gets the job done just fine. But in situations like this where you get a tip from a confidential informant, you're going to have to be able to articulate some factors, not necessarily going out and corroborating it, but totality of circumstances. What information can you put in your report? Can you put in your affidavit for your search warrant to show the judge that there is reliability to this informant's basis of knowledge? In this case, the court found they didn't establish that. They simply made an allegation that this is a reliable confidential informant. He contacted me and said this person was in possession of drugs, but they didn't list any basis for that knowledge. Don't forget that. You have to list the basis of knowledge if it's a search warrant or even if you're using as reasonable suspicion to make a stop. Prong number two is what we call the credibility or veracity prong, and that is where you have to show the judge, show the court that this is a reliable confidential informant. Again, usually that's accomplished based on their past history. You write in your affidavit, you list in your report, this is a reliable informant on 15 different occasions over the past several months, years, whatever, has given me reliable information that's led to arrests, convictions. Or you've made this informant reliable by doing controlled buys with them. Because you have to explain it. Prong number two wasn't addressed in this case. The court said this clearly was an informant that had a basis that had been used before. They didn't attack prong number two. Prong number one was the sole basis of this case. It was, did the task force give any information as to the basis of knowledge of the informant? And the court said no, they didn't. So this case suppressed the evidence on 2 points. Number one, they found that the defendant was seized applying New Mexico law, which is the moment that a reasonable person doesn't feel free to leave, you've given a show of authority, they're seized. We don't follow Fourth Amendment Hodari D, where they have to submit to it. So you have to understand that as an officer, if you're going to attempt to seize someone, even if they get away, they're seized for purposes of the Constitution as soon as a reasonable person doesn't feel free to leave, which means you must have reasonable suspicion to support that stop in that moment. Number two, if you're working drug cases, make sure you understand Aguilar-Spinelli. New Mexico doesn't follow Gates. That's the other Fourth Amendment test for using confidential informants or anonymous tips as the basis for a search warrant or reasonable suspicion. We only follow Aguilar-Spinelli. Make sure you understand those two prongs, the two-step. The tried and true method is controlled by. So when I was the HIDTA prosecutor, that was 99% of how we operated was controlled by, because that establishes those bases. Then it's up to you to make sure you articulate that in your report, in your affidavit for your search warrant. All right, so again, not anything new here. This is just New Mexico saying, hey, this has been the law for a while, but it seems like you guys forgot it. So remember, the law is different here. It applies differently. You got to stay up on the New Mexico law, because with HB4, with some of the reform bills that's being proposed in the legislature, your guys' exposure to lawsuits is incredible right now. And the biggest defense that you have is to be educated and know what the law is. That is the absolute biggest thing you can do to reduce your risk, your exposure to these harmful lawsuits, is get educated, know these cases, know the law. For my drug task force agents out there, for field officers that work in dope cases, end of March, I'm doing advanced search and seizure, where I'm going to talk about this case, and I'm going to go through how to draft your search warrant, how to work a confidential informant, and do it legally, in a legally sufficient way, so you're following New Mexico law. So don't forget to hit the subscribe button if you haven't done so already. There's a link to that upcoming course down there. If it's a course you want to bring into your agency, reach out to me. Let me know. I'd love to have you host one of these courses for the task force, for the officers in your area. So really important case here, guys. It's down there. Take a look at it. If you have any questions, leave them in the comments. Reach out. Let me know. All right, that's State of New Mexico versus Francisco Javier Granados. If you have any questions, let me know. That's all I got for you. Until next time, remember, every battle is won before it's fought. Get educated in the law. Stay safe. I'll see you on the next episode.